All right. Welcome to a national real estate exam prep. Today, we're going to go over a short lesson around agency. And then what we're going to do is we're going to dive into some questions that I believe that you're going to see on your national exam. And I'm going to give you the explanations to why the answer is the answer opposed to the other answers. So let's get this thing started. Firstly, I think that we have to go in mind, and when we look at agency, very first thing that we have to understand is the difference between a customer and a client slash principal. All right. So, firstly, your customer is not represented by the agent. All right. So, you as the real estate agent, you are not in a fiduciary relationship with a customer. All right. A customer, as it looks like, you do not have this fiduciary duty that is owed to them. Now, with that being said, it doesn't mean that it's the Wild West and you can just treat this person however you would like to treat them. You still must be honest. You have to be fair and you have to disclose defects. Also, you can't give advice or act on their behalf. All right. So, this is a third party to the transaction, is how I think about this. I think a customer can show up in two different ways. All right. So, I think the first way a customer could show up is you have an open house, you represent the seller. All right. Someone walks in off the street, they are unrepresented, and you would handle that person as a customer. You still have fiduciary relationships and responsibilities to the seller. And the person that walked in off the street would be a customer. I think the other way this could show up, and I would keep this in the back of my mind for the exam, is the third party to the transaction. So let's say, same scenario, you represent the seller and you were under contract on the property with a buyer. The buyer is represented by another agent. You would treat that person as a customer still. All right. So on your exam, what I would make sure that I understood was that the relationship that could be with my seller or my buyer, the third party would be treated as a customer, or the unrepresented person would be a customer. That's how the customer could show up either way. So then the next concept that we have to understand is the client slash principal. All right. These are going to be used interchangeably on your exam. And so they could say client, they could say principal. It means the exact same thing. All right. Same thing, different names. This is someone that you have an agency relationship with. And what we understand is when we have an agency relationship with someone, that means that we owe them fiduciary duties. All right. Now, let's bookmark this. Fiduciary. You have fiduciary duties to a client and a principal, not to a customer, not in a transaction brokerage relationship. The only time that you owe fiduciary duties is to a client or principal. Now, we're going to talk about fiduciary duties here in a minute, but let's just start programming it right now. We have cold AC. All right. COLDAC. This is an acronym. And this acronym, I think, could show up and help you for the exam when they give you a list of four different items. They say, which one of these is not a fiduciary duty? And you remember the acronym COLD AC. I think it's going to help you. Care, obedience, loyalty, disclosure, accounting, and confidentiality. And obviously we can change the C's in any order, but just know there's two C's. So COLDAC, care, obedience, loyalty, disclosure, accounting, and confidentiality. So remember, a client is someone that is represented by you. and a customer is unrepresented by you, but still treated fairly. So let's jump into these fiduciary duties. All right. When we have agency, this is a legal relationship. All right. An agency agreement creates a fiduciary relationship between an agent and a client, your client. So when we think about what governs this agency relationship, it's the law of agency. It's a statutory law. All right. The duties are legal. They're not just a moral, right? It's not just a, this is how I want to treat my people. No, this is governed by law. So your core fiduciary duties, again, care. The agent must use their knowledge and skill to act in the client's best interest. And if you failed to do this, this could be negligence, and there could be some legal liability there. The second thing that we have is obedience. You're going to follow lawful instructions. And you cannot obey illegal or unethical requests. And this would include, right, when we talk about fair housing, right? This is where this one would show up as well. We have fair housing. And if you were to have a client that would say, hey, I want this demographic of buyer to take over my home, we cannot follow that instruction. That would be unlawful. That would be illegal, right? They might say, guys, and just think about this. What does fair housing cover? Yes. And I think that we think about it, right? We're like, well, race, religion, ethnicity, sex, right? We think about all that, but also familial status. Familial status. They were like, I want a family to raise their kids here. Well, that would still be an unlawful instruction, which we cannot abide by. We also have loyalty, the client's interest above our own as their real estate agent with a fiduciary responsibility towards them. And this is where I think it will show up on your exam. It's going to be a commission-based question. All right. It's going to say that there's two houses and one of the houses is slightly better, yet you're going to get paid less. Which one do you show? You're going to show the slightly better one. All right. So we need to make sure that we are putting our clients' needs above our own. Disclosure. We have to tell our clients everything that matters, that we have to make sure that they are informed. This is also going to include material facts, whether favorable or not. All right. So where this could show up is if I am on the buy side and we realize that there's some issues with the property that I find out, I need to take this to my client. If I'm on the list side of things and I find out something happened, maybe it's a small town and I find out that the buyer maybe got fired from their job, well, that could be a material fact, right? They might not be able to qualify anymore. So it is my responsibility as the agent to make sure that my client is informed. When in doubt, always disclose. I think this is a good rule, everyone. Like, obviously, we're not going to go stigmatized, right? We know we're not going to go Casper. We are not going to go AIDS. We're not going to go homicide, suicide. We're not going to do any of that. Yet, what we will do is when we think that there is something that might be necessary or prevalent, we're going to disclose it to our client. Accounting, we got to track all their funds, right? We're talking about earnest money. We are talking about just accurate records. We need to make sure that anything that is related to the transaction, that we know where that documentation and that money is. Funds must be in an escrow, not mixed with your personal money, right? We're not going to commingle. There's no commingling allowed. We understand that's probably going to be a test question. And we understand that is how you get in hot water with the commission. And we understand that there's legal deadlines, right? We understand that there is deadlines for most everything that we're doing. We call them contingencies, right? We have contingency deadlines, and we are going to make sure that we're tracking and that we keep our clients informed. And then confidentiality. Keep clients' info private, especially around motivations, right? We're not going to say, hey, my client will do anything to get this deal done. Obviously, material facts are a little bit different. Yet, this is important, everyone. When we look at this and we talk about confidentiality, where we say, motivated seller, bring all offers, no offer too low. Well, I would say that's probably breaching some confidentiality, which is also why when we go through and we talk about implied agency, and when we go through and we are having a conversation with a customer, remember that person that walked into your open house and you represent the seller? Well, that person may walk in and start disclosing some information that you would be legally liable to disclose to your client. So that's why we say, whoa, 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 buyer, pump the brakes. Brokerage disclosure. I have an agency relationship with the seller. Anything you say can and will be used against you. So if they go in and they say the same thing and they're like, well, hey, I'm about to be homeless. This home checks all of my criteria. I would pay more than what you have it listed for. Well, that's going to create a conflict of interest, because if we did not disclose that we have an agency relationship with our seller and that we must disclose, well, they just gave us confidential information thinking that we might have been their agent. And now we might have an implied agency, dual agency situation. So when we're looking at this thing, remember, all fiduciary duties are legal obligations. They're mandatory. All right. This is not this is how I treat my people because I love them. No, this is a legal obligation. There is legal risk and harm to your client. And we know the commission's in place to protect the public. And this is how bad things happen to real estate agents. So remember, for your test, the acronym, hold AC. All right, let's jump into this thing. Let's talk about express agency. All right. Express agency is through written or spoken agreement. Both parties, the agent and the client, have agreed to this agency relationship. And when we think about this, we obviously the written listing agreement, buyer agency agreement, we understand this, right? That is your employment agreement. So when you see listing agreement and buyer agency agreement, those are going to be agency relationships. Those are going to be your employment agreement with your client. And while oral agreements are allowed in some states, they're not enforceable. All right. When we talk about the statute of frauds, for it to be enforceable, it must be in writing. Obviously, the best practice is to always get your agreement in writing. All right. It's legally stronger, and you have clearly identified the playground rules in writing, and you have signatures. Oral agency agreements, they may exist. All right. The national exam, they may exist. But if there is an issue or dispute to your compensation, you actually need to have written proof. All right. So a written agency agreement not only makes it more clear for all parties involved, but it has more protections for the agent. But then we have this thing called implied agency. Well, implied agency, there's no formal agreement. So it's not written, And it was not a verbal agreement either, right? We did not say, hey, do you want to be my client? And they said, yes, I would love for you to be my real estate agent, right? That conversation did not happen. This was actually created through our actions and our behaviors, right? And it says, if it acts like an agent, it's an agent. And that's why I was telling you about when we're doing the open house. And this is where you can get into hot water, right? We have an open house. We represent the seller. Unrepresented buyer walks in. Unrepresented buyer walks in, gives us motivations. We don't tell them to stop. We don't tell them who our fiduciary relationship is for. And so they tell us all their motivations. They tell us financial information. They tell us that, hey, we're going to be kicked out of our house in X amount of days, and this home meets all of our criteria. Well, through your actions, I think you might have an implied agency agreement now. And with that being said, there could be some legal implications if this goes sideways for either party, the buyer or the seller now. So when we're thinking about this, here's a couple examples. You show buyers a FSBO home after the seller tells you to bring buyers, right? This could look like an implied agency. You negotiate on the seller's behalf. And the court may decide that you and the seller created an implied agency based on your actions, even though it was unintentional, right? FSBO, for sale by owner. You went on to Zillow, you found a house, you talked to the seller tells you, hey, yeah, just bring me some buyers. So you find a buyer, you negotiate on the seller's behalf. Who were you representing? Based off your actions, it looked like you might have been representing the FSBO, the seller that was representing themselves. Unclear expectations create legal disputes over commissions. Always, always, always clarify relationships early. This avoids confusion and lawsuits. So let's talk about these employment agreements, right? The employment agreement, this is why you are all getting in this thing. You are not getting into real estate to be a nonprofit. You are getting into this thing to make money. Money is good for the good that money can do. And so I hope you all make as much money as possible. So when we're looking at this thing, let's talk about the exclusive listing and exclusive agency. All right. Two different contracts, national exam. You have your exclusive right to sell. One broker is hired. All right. Only one. The broker earns a commission no matter who sells this property. All right. I think about this. The most protections for the agent. All right. So if I'm taking notes, the exclusive right to sell has the most protections for the agent. What we know about the exclusive right is that you have to have a specific termination date. We start on this date. This agreement's over on this date. If the seller were to sign two exclusive listings, they may owe 2 commissions. All right. There is only one commission paid to the listing broker who may share it. All right. So when we're looking at this thing, yes, the seller could screw up and sign 2 of these. Absolutely. But for the most part, they understand not to. That's where we jump to that last bullet point. There's only one commission paid most of the time. Because on your exam, I think what you're going to see is called a co-op. So a cooperating broker. For exam purposes only, cooperating broker, 1 commission paid. And what this looks like is, let's say the seller is at the dining room table with the agent, and the agent asks about compensation. And from there, the agent goes further and says, would you allow me, Mr. and Mrs. Seller, to take a piece of the commission that you are paying me to offer to the co-op. The co-op is always the buyer's agent. All right. For my exam, co-op is the buyer's agent. The second agency agreement, the second employment agreement is the exclusive agency listing. One broker again is hired. Just like the first one, only one broker is hired. Yet the seller reserves the right to find their own buyer, which means the broker must be the procuring cause to get paid. Exclusive right, most protections for the agent. It does not matter where the relationship comes from and the agreement gets signed, the agent gets paid, most protections. The exclusive agency, the agent must be the procuring cause to get paid. Now, again, this one's rarely used just because of commission disputes, right? Like, how do you prove where this buyer came from, right? The buyer came from an open house. Did they knock on the door? Was there a previous relationship? Especially if you start thinking about like a smaller town, right? Like this kind of stuff could pop up. We have two more agreements. We have the open listing and the net listing. Your open listing, this is multiple brokers. All right. All the brokers, right? They are looking and they are competing to find the buyer for the seller. Only one broker will earn a commission because they are the procuring cause. All right. So, kind of similar to the exclusive agency where you have to be the procuring cause. Yet the difference is that there's multiple brokerages that are competing at the same time. The broker's risk is that you could be putting some advertising dollars or advertising energy into finding the buyer and not earning a compensation. Then we have a net listing. All right. So the net listing is a little bit different. All right. And I do think we're going to see a net listing question on the exam. So when we're looking at this, the seller sets a minimum price that they want. The broker keeps anything above that amount. All right. Seller sets minimum. Broker keeps every dollar above that minimum sale price. Here's your example. The seller wants 500K. All right. So for whatever reason, this is how you set this up. And let's say the broker sells the home for $550,000. That means the broker's compensation would be $50,000. Here's your problem. The broker may have done this knowing what the home would sell and misled the seller. It is illegal in most states due to this conflict, and yet it's still in enough states to where you're going to get tested on it. I want you to know this from your key takeaway. I actually think that the test question for this specific agreement is that it's legal, yet may entice the agent to act unethically. I actually think that's how they're going to lay this thing up. They're going to say, hey, it's legal, yet the agent might act unethically because of how they could set this up. And this is what I would say. You do this to take advantage of the public. And really what I think the advantage of the public looks like would be if you earn compensation that is higher than what the historical average looks like for the area, I think you could be in some hot water. So not only the hot water, but this is when the commission is going to get involved. And I think you could lose a license over it. Net listing, legal yet may entice the agent to act unethically. Exclusive right, most protections for the agent. Exclusive agency, must be the procuring cause, only one brokerage involved. Open listing must be the procuring cause, multiple brokerages involved. All right, now we're shifting gears. We have 10 questions. And with those 10 questions, they're going to line up. So participate along, get out your pen and paper. Let's think about this. The type of agency that exists when a broker represents the seller or the buyer, but not both, and a transaction is a designated agency, dual agency, single agency, facilitator, or transaction broker. The answer is C. It's single agency. Single agency means the broker represents only one party, either the buyer or the seller, but not both. Dual agency, you're representing both parties, which is not allowed in many states, but yet allowed in enough. Designated agency, the broker appoints different agents for buyers and sellers within the same firm. And transaction brokers don't have fiduciary duties to either party. A salesperson representing a seller suggests to a buyer that the seller might accept less than the listing price. The salesperson in this situation may have unintentionally created undisclosed dual agency by suggesting the buyer offer less than the listing price, is simply performing a ministerial act for the buyer, is fulfilling his fiduciary responsibilities to the seller by encouraging a buyer to purchase the property, no longer represents the seller because he has given advice to the buyer. It's A. May have unintentionally created an undisclosed dual agency by suggesting that the buyer offer less than the listing price. By giving advice to the buyer, the salesperson may have implied that they represent the buyer too, creating an undisclosed dual agency, which is illegal in most states. This also violates loyalty and confidentiality owed to the seller. Ministerial facts or acts involved no discretion or advice. The agent still represents the seller despite this breach. A contract that secures the employment of a brokerage firm to find a ready, willing, and able buyer for a seller is an escrow account, a listing contract, an option contract, or a sales contract. And it's a listing contract. This is a personal service agreement. This is your employment agreement between a seller and a brokerage firm to find a ready, willing, and able buyer. A sales contract is between the buyer and the seller for the purchase of a property. An escrow contract outlines the role of the escrow holder, and an option contract gives someone the right, but not the obligation, to buy. A buyer entered into a buyer agency agreement that gave him the right to purchase property on his own and not pay the buyer's agent. This best describes an exclusive agency buyer agency contract, a designated buyer agency contract, an exclusive right to buy buyer agency contract, an open buyer agency contract. The answer is an exclusive agency buyer agency contract. In an exclusive agency buyer agency agreement, The buyer can purchase property on their own without owing their agent a commission. Exclusive right to buy means the agent gets paid no matter what. Designated agency refers to an agent in a firm which represents the buyer, not commission rights. And an open buyer agency allows multiple agents and only one who is the procuring cause gets paid. All of these are valid reasons for terminating a listing contract except sale of the property, death of the salesperson, destruction of the premises, agreement of the parties. Death of the salesperson. A listing contract is between the brokerage firm and the seller, not the individual salesperson. If a salesperson dies, the listing remains valid. Valid reasons for termination would be the sale of the property, destruction of the property, mutual agreement, or death of the seller or broker, not the salesperson. A broker may act as a dual agent and represent both the seller and the buyer in the same transaction if the broker informs either the buyer or the seller that the broker is representing both parties to the transaction. Both parties are represented by attorneys. Both the seller and the buyer give their informed consent, usually in writing. The seller and the buyer are related by blood or marriage. Both the seller and the buyer give their informed consent, usually in writing. Dual agency is only legal in the states that allow it, and both parties must give informed written consent. Informing only one party is not enough, and having attorneys or relationships between the buyer and the seller does not eliminate the broker's need for written consent from both sides. Which statement is true of a listing contract? A seller must transfer the property if the brokerage firm produces a ready, willing, and able buyer. The contract is an employment contract for the professional services of a brokerage firm. It obligates the brokerage firm to work diligently for both the seller and the buyer. The contract usually includes an automatic extension clause upon expiration of its terms. The contract is an employment contract for professional services of a brokerage firm. A listing contract is an employment contract, not a sales contract. It obligates the brokerage firm to market the property and seek buyers. The seller is not forced to sell unless they agree to the terms. The firm represents only the seller, not both parties. Automatic extensions are not standard and often not allowed by law. Contracts require a definite termination date. A buyer has signed a contract with a broker to compensate the broker even if the buyer purchases the property from a relative. This is called an exclusive agency buyer agency contract, an invalid contract, an open buyer agency contract, an exclusive buyer agency contract. An exclusive buyer agency contract. In an exclusive buyer agency contract, the buyer agrees to pay the broker regardless of who finds the property, even if the buyer purchases from a relative to find it independently. Exclusive agency limits payments to where the broker finds the property. Open agency allows multiple brokers and only the procuring one to get paid. The contract is valid if properly executed. A salesperson working with a customer knows that the neighborhood he is showing is very near an airport with low-flying planes that create a lot of noise. The salesperson should disclose the level of airplane noise in the material information, material fact, material defect, material breach. This is a material fact. A material fact is any information that could influence a buyer's decision to buy a property. Airplane noise could affect a buyer's willingness to purchase, so it must be disclosed. A material defect relates to physical issues in the property itself, and a material breach refers to the contract violations, not disclosures. Which of these does not create an agency relationship? A property management contract, a listing contract, a buyer agency contract, the payment of money or commissions. The payment of money or commissions. Agency is created by written contract of the actions of the party, not payment alone. Listing, buyer agency, property management contracts all establish formal agency relationships. Commissions are the results of an existing agency, not what creates it. All right, we should be looking back and saying, how did we do? Right? This is a huge piece of our national exam. Agency relationships, as well as contracts, are going to make up the majority of your national exam.